What a mess if they have created. I don't know why they would do that. That's really
Let us begin. I'm honored to invite Honorable Justice Mr. A.K. Jayashankaran Nambiar, Judge, High Court of Kerala. Shri P. Rajiv, Minister for Law. Shri Dushyant, Senior Advocate and former President, Supreme Court Bar Association. Shri Gopalakrishna Kurup, Advocate General, Kerala. Shri V.K. Biran, Senior Advocate and former Additional Advocate General and Vice President, Ernakulam Law College, Old Students and Teachers Association. Dr. Bindu M. Nambiar, Principal, Government Law College, Ernakulam. Shri P. Sanjay, Secretary, Ernakulam Law College, Old Students and Teachers Association. Onto the dais. Dr. B.R. Ambedkar, widely known as I also invite Shri P. Shantamekam, Senior Advocate and President of the Ernakulam Law College Old Students and Teachers Association. Dr. B.R. Ambedkar, widely known as the father of the Indian Constitution, noted, "The Constitution is not merely a lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age." On that note, I extend a very warm welcome and a very good morning on behalf of the Ernakulam Law College Old Students and Teachers Association to the dignitaries on and off the dais and everyone present here for this year's annual lecture on the basic structure of the Indian Constitution and its present-day challenges. We are honored by the august presence of Honorable Mr. Justice Jayashankaran Nambiar, Shri P. Rajiv Sir, and Shri Dushyant Sir, who will be rendering the annual lecture on the subject. Let us begin this august function by evoking the blessings of Lord Almighty. I hereby invite Ms. Ansel Shine onto the stage for invoking a prayer.
अखिलांड स्नेह सार में अकतारिलमृदु निरैक्यणे अഴലോടെ നിൽക്കും മടിയരിൽ തവ സ്നേഹ ശാന്തി നിറയ്ക്കണേ അഖിലാണ്ട സ്നേഹ സാരമേ അകതാരിലമൃദു നിറയ്ക്കണേ അഴലോടെ നിൽക്കും മടിയരിൽ തവ സ്നേഹ ശാന്തി നിറയ്ക്കണേ അഖിലാണ്ട സ്നേഹ സാരമേ അകതാരിലമൃദു ജീവിതത്തിൻ സമൃദ്ധിയിൽ സമഭാവമോടെ പകുത്തിടാം, സമഭാവമോടെ പകുത്തിടാം. സൗഹൃദത്തിൻ തന്ത്രിയിൽ വിശ്വസ്നേഹഗാനമുണർത്തിടാം, വിശ്വസ്നേഹഗാനമുണർത്തിടാം. ഞങ്ങൾ സ്നേഹഗായകരായിടാം, തവ ശാന്തിവാഹകരായിടാം. ഞങ്ങൾ സ്നേഹഗായകരായിടാം, തവ ശാന്തിവാഹകരായിടാം. അഖിലാണ്ട സ്നേഹസാരമേ അകതാരിലമൃദു നിറയ്ക്കണേ.
To render the welcome address.
We are starting the function at 11 o'clock itself. The Honorable Minister is on the way and he will most respected senior advocate, Mr. Dave, Dushyant Dave, and Mrs. Dave, and the Honorable Minister is coming. The President of our association, Sri P. Shandalingam, Senior Advocate, Principal of the College, Government Law College, Ernakulam, Sri Bindu Nambiar, Srimati Bindu Nambiar, and Sri Sanjay, the Secretary of the Association, and very respected audience. Among that, the Honorable Mr. Justice V.K. Mohanan is present. I'm very glad. And all so many honorable guests are here, heeding our invitation, and we are happy, and also they are also present here. Now my duty, my responsibility is to welcome you all to this August function. This is a very, very, very happy occasion that we are organizing a function in the name of the Maharaja Law College at Ernakulam, which has been originally established in 1874, and it was shifted to Ernakulam after the independence in 1948, and started the classes in the Cochin, erstwhile Cochin Assembly Hall. That is still there, the classrooms are there. And we are very happy that we were students. We were very fortunate to have this alumni. And now our August meeting is presided over by the Honorable Mr. Justice Jayashankar Nambiar, who is also a alumni of the Law College and hails from the judge's family. Everyone knows it. And I heartily welcome His Lordship for his presence. And our chief guest, today's chief guest, Sri Dushyant needs no introduction among the lawyers and the legal fraternity. And he was, my relationship with Mr. Dave was just like an umbilical cord relationship. That is, we had a very, very long relationship, and I had the fortune some 24 years back to visit his ailing father in the Baroda hospital in Gujarat, who was the judge of the High Court of Gujarat. And really it is a pleasure that we are, I claim that I am one among his family, and I can very, very easily say that he will come to any function when we are, if he is needed. And I am very happy. And his wife also is here, Mrs. Dave. And I welcome both of them on behalf of this August gathering to this meeting. Now the Honorable Minister for Industries and Law, and he is very happily agreed to come, and he is on the way because, you know, the situation in Ernakulam, and there are so many issues regarding the government, and he is handling most of the issues. And he just now also he telephoned to some 10-15 minutes back. He telephoned to me, and he is on the way. And he permitted us to start the meeting, and he is the inaugurator of the meeting. He is inaugurating this August meeting. And in his absence, I welcome him also to this function. Now the learned Advocate General, Sri Gopalakrishna Group, is here, and he is one among us. And I am very happy to welcome him to this function. And the president of this association, our Honorable Minister, is coming, very happy, and you give a long clap. Already we welcome the Honorable Minister. Now our function is full. Everything is full. Very happy. And every guest come, every invitees come, and now I welcome our President P. Shandalingam, Senior Advocate, to this function. And the principal of the meeting, Srimati Bindu Nambiar. She is now controlling everything in this law college, and he is very happily present here to address you. I extend a warm welcome to her also. Now, the Honorable Minister, Honorable Justice Mohanan, and V.K. Mohanan, and also so many VVIPs are here. I cannot because of lapse of time, I cannot name each and every one, but all are very important people, very intellectuals. Everyone wants to know about the Constitution and present challenges also, the basic, especially about the basic structure of the Constitution. What is the basic structure and everything, I need not explain to you, but you are going to hear it from the authoritative mouth. And he is he will, and after his lecture, of course, there will be an interactive session. And everyone who is interested may kindly put the questions and get their doubt cleared. And I extend a warm welcome to all concerned, all present here, with a very, very happy mind, and thank you all.
Thank you, Shri V.K. Biran sir, for rendering the welcome address. It is my absolute honor to welcome Honorable Mr. Justice Jayashankaran Nambiar, Judge, High Court of Kerala, to render the presidential address.
Distinguished guests on the dais, a special welcome to the Honorable Minister Rajiv, the Speaker of the Day, Senior Advocate Mr. Dushyant Dave, my good friends of the bar, Mr. Biran, Mr. Shantlingam, Sanjay, and of course the Advocate General Mr. Gopalakrishnan Kurup. And I'm not leaving you out, Bindu, the principal of the Law College, and my good friends from the bar, ladies and gentlemen. I've often found it amusing that whenever there is a mention about the basic structure doctrine these days, there is an air of uncertainty, there's an air of skepticism, there's fear, a whole range of emotions comes into play whenever the word basic structure doctrine is mentioned. And quite frankly, I've been amused by it because I really don't know why there must be an apprehension whenever somebody discusses a matter of constitutional importance, and especially when that matter is also something that involves the interpretation of the Constitution. I would think that in a democracy like ours, a very vibrant democracy, if I may call it, there is an active discussion about the governing document, which is the Constitution, should be encouraged and should be treated as most welcome. Today we have with us Senior Advocate Dushyant Dave, who can indeed fuel that excitement. From what I know of him, from the days in the Supreme Court, he can really fuel a debate. And he will push you to the brim and make you, or maybe I should use the word push you to a corner, with a view to extract from you your views on the subject. And I think he will do that today. But let me put in my 2 pennies worth of what I think about the basic structure doctrine and why I'm so amused by the fact that people shy away from a discussion about the basic structure doctrine. See, as a student of constitutional law, and I think all of us in the legal fraternity should remind ourselves that we are never masters of the law, we are always students of the law. And all these degrees that we get are a bit misleading in that sense, because we call ourselves at various times depending upon the extent to which you choose to study, you're called the Bachelor of Laws, you're called a Master of Laws, you're called Doctor of Laws. These are all misleading things because you're never any of those. As a lawyer, you're wedded to the laws, so you're not a Bachelor of Laws. As a postgraduate, you continue to be a student of the laws, you're never a master of the laws. And a doctor of law, forget it, you're going to be always a patient. Because it's going to tell you things which you never really understand. So what we actually understand from the reading of the Constitution is that it's an evolving document. And it's an evolving document because it is never static. It can never be static because it's a governing document. And when you call it a governing document, it's a document that governs society. It's a document that governs people. And so, as long as you have a change in society, as long as you have a change in the attitude of people, you're going to have the Constitution falling in sync with those changing attitudes, and it has to be an ever-changing document. So its interpretation has to be dynamic, and you all know that. The Constitution, as in the United States, is what we call a living Constitution. It lives, it breathes, it grows. So when you're talking about a Constitution which is an organic document, and change is the only constant, this concept of having an implied limitation on that change sounds a little bit of a misfit. I was saying that the Constitution itself is an organic or an evolving document. If you actually read the Constitution, you don't need to look any further than Article 368, which talks about the possibility of its amendment. Now, if a document is supposed to be frozen in point in time, it would never actually provide a clause for its amendment. And therefore, the amendment provision itself signals the need for a change or the idea that it should be changed in future times. And that's not surprising because, as Gautam Bhatia calls it, it's a transformative constitution. Rohit Day, another great significant jurist and an author, he calls it the People's Constitution. And the reason he calls it a People's Constitution is because people have a say in guiding the judiciary in interpreting the provisions of the Constitution. So he calls it a People's Constitution. Probably the greatest biographer of the Constitution, Granville Austin, he calls it the cornerstone of a nation, the central governing document. And he also says a very important thing. He says, please remember that the Constitution of India is first and foremost a social document. It's not a legal document. And this, I think, is where we get confused. Because we start looking at the Constitution just as any other legal document. You start interpreting it as a legal document, as a legal deed, when it's not all that. The interpretation of a Constitution must always be different. It must always be different from what you would do in the case of an interpretation of a legal document. Now, what is the Constitution? As I said, when you're talking about an evolution or a growing or a living Constitution, what are the other features which you find in the Constitution which signal the need for a change, the ever-growing need for a change? One is, of course, the provision which provides for its amendment, Article 368. The other is Part 3 and Part 4 of the Constitution itself. Part 3, as you all know, deals with the fundamental rights. They're more or less in the nature of entrenched provisions, limited entrenchment, because Article 13 says that the state shall not make any law that takes away or abridges any of the rights or any of the provisions in Part 3. And that shows the intention of the framers that there are certain human rights, basic rights, which are not meant to be tampered, except if you want to increase their scope and ambit. That's where the words uses you cannot take away or abridge. An enhancement is not ruled out. So you can, by amendment, enhance the scope of the rights that are granted in Part 3. But Part 3 itself mentions only certain rights. And the reason for mentioning or restricting it to only those rights is because in Part 4, you must understand that when the debates in the Constituent Assembly were taking place, they were not there to find a solution for all the problems that were faced in society on that day or those days. Because there was a lot of it which could not be resolved. Take, for example, the Uniform Civil Code. Nobody could find a solution for the Uniform Civil Code. And therefore, what do? How do you find a solution overnight? You can't. Because you have to see how the society develops. What are the changing attitudes in society? What is good today may be bad tomorrow. So let's not freeze the Constitution for all time to come. Because that would be like the Americans say, the dead hand of the past governing the future. We don't want that. You need a constitution that will always remain as a governing document and remain relevant as a governing document. So you need to confine what you're freezing to the bare minimum, because if you do more than that, then you're actually controlling the constitution. You're preventing it from evolving. So when it came to those issues on which there could not be any settlement or consent, that was put in Part 4, the Directive Principles of State Policy. And how was it supposed to be guiding the governance at any given point of time? The Directive Principles of State Policy are precisely what they say it is. They are directive principles which should inform the government in power to frame policies. It should inform the state as to how it should go ahead. Keep these things in mind when you make laws for a society. So, what is apparent from a joint reading of Part 3, Part 4 and Article 368 is that there is an inbuilt scheme of incremental empowerment of the citizenry. And this is important. And it's important because you need to understand that the Constitution was never meant to be static, even at the time of its inception or even at the time of its adoption. The framers deliberately put in a clause, Article 368, for its amendment, Part 3, Part 4, providing for an incremental empowerment. It is not something to be achieved overnight. Even your fundamental rights. We had grandiose concepts therein, privileges, fundamental freedoms, fundamental rights, equality, liberties. Under Article 19, you have the right to life under Article 21. But take, for example, the Equality Clause. Equality before law, equal protection of the laws, equal opportunities, equality of status and opportunity, as the preamble says. Could this have been realized in society overnight? We adopted the Constitution in 1949, 1950, January 26th is when it formally came in. On January 27th, 1950, can we say that we can achieve equality in a society? No, it takes time. So what was so fundamental in a fundamental right that was guaranteed through the Constitution with immediate effect in Part 3? It was an ideal, it was a concept, it was values that was enshrined, and basically the message sent was these are not negotiable. So you have to live your life from the next day keeping these things in mind, that it's like a new law which says you can't do this. So from the next day, after the Constitution came into effect, you need to live your life in society keeping in mind that these are the rights that others have which are not negotiable, which cannot be abridged, which cannot be taken away. As for the ideals in Part 4, work towards them. Time will tell you whether this is good or bad. But keep that in mind, because this is our culture, this is our society. And therefore keep that in mind when you make laws in the future. Those are actually directions to future parliaments of the day. And when you're talking about such a scheme of incremental empowerment, the question naturally that is asked is, where is the scope for a provision for limitations on that power to amend? And this is where the basic structure doctrine comes in. So, against the backdrop of a scheme of incremental empowerment of the citizenry, which is inbuilt in our Constitution, against a scheme of change that is inbuilt in our Constitution, how do you explain an implied limitation There are express provisions in the Constitution which limit Article 13(2). It says that you shall not abridge or take away only those rights in Part 3. What about the other provisions outside of Part 3? Are they to be taken away? Are they to be abridged? And if they are, who is to say so? Why should the basic structure doctrine propounded by the judiciary be seen as freezing the Constitution in that regard for all time to come? These are questions that are normally asked, and they will be asked, and they will continue to be asked, because it militates against the basic scheme of our Constitution. And I think, therefore, it is important that we engage in these discussions and deliberations to find answers to the many questions that are coming up before us today. First of all, if there is going to be a change, who is to effect that change? Is it going to be the judiciary? Is it going to be the Parliament, which is the body that is stated in the Constitution as having the power to amend the Constitution? Why was it that in Keshavananda we had the basic structure doctrine propounded by the judiciary? So why did the judiciary feel it necessary to take control? You have to understand this in the backdrop of the changing political scenario in the country. What happened in 1973 need not be what happens in 2023. And therefore, you're going to have situations where you're going to re-examine, introspect on the laws that were there earlier. And that's the very essence of a thinking population. And that's the essence of democracy. You need participatory, inclusive democracy. And every citizen who is governed, equally as those governing, must have a say in the matter of governance. And this is where these debates become significant. And as Indians, we all know that when it comes to loquaciousness, we are unrivaled. We had the late Defense Minister V.K. Krishnan, who is reputed to have spoken for 9 hours non-stop in the UN General Convention, General Assembly. Who was there to listen to it for the entire 9 hours, I do not know, but it is one of those things that reflect what Amartya Sen calls as the argumentative Indian. See, argumentative Indian, as Indians, we specialize in whatever creativity that we have is a result of our arguments. And more so in Kerala. There's nothing that is not argued in Kerala. I remember somebody shouting a slogan saying, "Mr. Bush, go back," in Boat Jetty in Ernakulam, when George Bush was brave enough to come and visit New Delhi. There was also another person in Udayamperur who said, "Mr. Bush, we can put up with any of your policies, but if you touch Nicaragua, we are not going to remain silent." That's the spirit that we have. And I think that's a good spirit. I mean, these are the exceptions. But I think that's a good spirit to have, because it fosters debate. And unless you become argumentative, you don't get the best out of the person you're arguing with. And together, this can be a constructive exercise. And I think that's what we are here today for. I will not detain you any longer, and we have a very good speaker to address us on any queries that we may have or any doubts that we may have about the continued operation of this basic structure doctrine. So I thank you all for the time. I thank the organizers. I must congratulate the organizers for having put up this function today, so that we get to hear an outstanding speaker communicate his views about the basic structure doctrine. Thank you.
Thank you, Your Lordship, for the enlightening address. Indeed, let us keep evolving and growing as a society through discussions and deliberations. It is my honor to introduce Sri P. Rajiv, the Minister of State for Law, Industries and Choir. His other portfolios include industries, commerce, mining and geology, handloom and textiles, khadi and village industries, cashew industries and plantation directorate. May I now invite Shri P. Rajiv sir to render the inaugural address.
I'm President of the meeting, Honorable Jayashankar Nambiar, respected Senior Advocate Dushyant and Honorable Advocate General of the State, Advocate Gopalakrishna Kurupu, Advocate V.K. Veeran and other dignitaries who are present here on and off the dais, and dear friends. At the outset, I would like to congratulate Advocate V.K. Veeran and office bearers of this Alumni Association for selecting the theme of the debate and selecting the speaker of the day, the fiery exemplary speaker, former President of Supreme Court Bar Association, Dushyant. The subject is very relevant in the contemporary India, the relevance of basic structure. It is the general feeling in a country like India, it is not an easy process to dismantling the basic structure of the constitution. That is a general feeling. A conditioning process is going on. Ambedkar has correctly stated in the Constituent Assembly, without dismantling the constitution, by the practice against the principles of the constitution, you can dismantle de facto the constitution. That is happening in our country. The basic structure, all of us are well aware that. I would not like to take more time. Actually, I have a very hectic schedule today, but I think at least register my presence is a primary responsibility, not only as a Minister of Law, but as a alumni of Government Law College, Ernakulam. And I will miss the speech of senior lawyer Dushyant. I have to inaugurate one missionary expo of my ministry at 11 o'clock at International Stadium here. All of us well aware that one of the basic structure is secularism. And in a secular country, the religion should not be a criteria for giving citizenship. Dr. S. Radhakrishnan has specifically mentioned and had specifically mentioned in the Constituent Assembly that in a modern world, religion should not be a base for nationality. And Jawaharlal Nehru had added that religion should not be a criteria for giving citizenship. That is, we could see in the Article 5 to 11 of the Constitution of India. Jus Solio is the principle we have adopted by adopting these 5 to 11 articles of the Constitution with regard to citizenship. But what is happening now? Now, religion is one of the criteria for giving citizenship. While religion is becoming a criteria for giving citizenship means that the country is moving from a secular state to a religious state. The journey from a secular state to a religious state means simply a journey from democracy to fascism. That is the reality. But it is true, no amendment to 5 to 11. Article 11 gives powers to the legislator, parliament, to make laws with regard to citizenship. It is there. But still, secularism is the basic structure in the papers, continuing. But what is the reality? Then, democracy, parliamentary democracy is another basic structure. I would not like to go to all details. Article 93, 94 is there in the Constitution now itself. As per Article 93, the House of the People shall choose 2 of its members as soon as may be as a Speaker and Deputy Speaker. Now we are going to the next election. The Parliament has no Deputy Speaker till today. Article 93 is there as soon as may be. There is a scope for wide interpretation of these words as soon as may be. It is same in the Article 200, while giving the assent to the bills as early as possible. These are the some words for wide interpretations. This there, 94, Article 94, while a speaker is going to be submit a resignation, he should submit the resignation to the deputy speaker. It was a great debate in the Constituent Assembly to whom the speaker should submit his resignation. There was an argument it should be to the president of the country. No, because president of the country is a part of the executive. Legislator has its own independence. Then the speaker, whenever he wants to submit a resignation, he should submit the resignation to the deputy speaker of the House of the People. That is Article 94. Then as per Article 94, there is a constitutional responsibility to a deputy speaker, but House of People is not ready to select any of its members as a deputy speaker while enjoying this much of majority. Still parliamentary democracy is here. Several other examples. But without amending the Constitution, as correctly stated by Honorable Justice, 368 is there, the amendment powers, it is there. But without amending by practice, federalism. In Constituent Assembly debate, Ambedkar once had intervened and said there should not be a cap for fixing sale tax, because the state should have at least that much of fiscal independence. But now GST is there, everything is concentrated. As per 343 of the Constitution, we have no national language, no regional language, but always we are mentioning Hindi is our national language, Malayalam is a regional language. No. As per 343, we have only official language, Hindi in Devanagari script and up to 10 years for English. Schedule 8, official languages, no regional languages. Malayalam is not a regional language, it is an official language as per Schedule 8. Tamil is not a regional language, it is an official language by Schedule 8. But always we are propagating national language, Hindi and regional language, Malayalam and Tamil, centralizing. Hindustan, no. Article 1, India, that is Bharat, shall be a union of states. There was a healthy debate in the Constituent Assembly. The name of the new country should be Hindustan. Some of them argued for Hind, some of them argued for Bharatavarsha, some of them argued for Bharatkhanda. But Constituent Assembly unanimously had decided the name of this country is India. That is Bharat, not Hindustan. Rejected. But all of the rulers of president, prime minister, ministers, always mentioning Hindustan. This against Constitution is there, but the public opinion manufacturing like this. There are several other examples. I would not like to go to the details. After 42nd Amendment of the Constitution, entry 32 in the state list. What is entry 32 in the state list? That is the legislative competency of the state legislature for incorporation and regulation of universities. No amendments, even in the 42nd Amendment, it is there. Entry 32. It is full power to state assembly, legislative assemblies for regulating and incorporating universities. That is true, entry 25 in the concurrent list after this 42nd Amendment. Entry 25 is not open, it is subject to 63, 64, 65, 66 of the entry union list. Not open. 66, determination of standard. In the Constituent Assembly, Ambedkar correctly mentioned what is determination of standard. If Madras University giving Bachelor of Arts or Bachelor of Science degree certificate for a student who attained 45% of marks, University of Mumbai giving the same certificate to a student who attained 30% of marks, another university giving the same certificate for a student who attained 60% of mark, then there should be asking the candidate should be a graduate, then there should be a standard. This is the intervention by Ambedkar in the Constituent Assembly. That is the determination of standard. 66 giving powers to the UGC, 25, 26 regulatory powers in the UGC Act. But in UGC Act 26 means determining the basic qualification of the teaching faculty by wide interpretation. Now taking out all the powers of the Legislative Assembly to the Parliament. Still federalism is the basic sector. 32 entry 32 in the state list is there. But taking over all the powers of the Legislative Assembly with regard to the universities, regulation, incorporation to the Parliament. With no amendments. The 368 is there, there are provisions. That is the reality of the day. Recently, Honorable Supreme Court has made a verdict interpreting Article 3 of the Constitution. The Parliament has the power to make law to convert a state into a union territory. You are going to the Article 3, there is only one sentence. The last provisional state is union territory is also considered as a state in this article. But wide interpretation, that is happening in our country. Then without amending the Constitution, the basic structure should be amended in practice. Other side is not easy because 13 bench verdict on case Vananda Bharati case is there. That is Honorable Vice President has mentioned that case. Then they want to cementing this organ, judiciary with executive. Now the demand to executive judiciary, executive legislature, executive media. I am concluding, now country of Israel is witnessing an unprecedented protest. The Prime Minister of the country is airlifted to the airport. But no pilot is ready to take charge of the flight. For the Prime Minister, he wants to go to Italy along with his wife. A part of protest against a new judicial reform bill of Israel. Israel is a country almost almost of the time of the history is a extreme right ruled country. The Israeli parliament recently passed the first reading of the bill by a voting 60 to 48, changing the constitution of the committee for electing the judges, 333, executive 3, legislature 3, and judiciary 3. Earlier, deleting 2. Earlier there was a provision for 2 from the bar. This reduced 11 to 9. And judiciary, earlier Chief Justice and sitting judge, now it has been changed. Chief Justice plus retired judge, decided by the executive with consultation of the Chief Justice, President of the Supreme Court of Israel. Then totally cementing, taking over the appointing authority of Justice of Israeli Supreme Court. And another part, as India, judicial review is there. If a bill is passed on basic laws, the Supreme Court has the power to annul it. But with a simple majority, as per the new bill, the Parliament has the power to overrule it. Then they can pass the bill again. Then totally an extension of the executive. But unprecedented protest is, Israel is witnessing unprecedented protest against the bill. The same thing is happening in another manner in our country. But it is not coming to the public debate. That is why I would like to congratulate V.K. Biran and his team for taking this subject. And also, this type of debate is the need of the day of the country. All of us should take part of this discussion. And by these words, I inaugurate this seminar. Thank you. Thank you very much.
Thank you, sir, for the illuminating address, nudging our attention towards the present and prevailing issues. kindly rise? In the words of Advocate Nani S. Palkhiwala, the Constitution of India was meant to impart such a momentum to the living spirit of the rule of law that democracy and civil liberty may survive in India beyond our own times and in the days when our place will know us no more. On that note, it is an honor to introduce Shri Dushyant Dave, Senior Advocate and former President, Supreme Court Bar Association, who has commanded practice across the Indian subcontinent for over 3 decades. It is my absolute honor to invite Sir to deliver the highly anticipated lecture on the basic structure of the Indian Constitution and its present-day challenges.
Good morning, everybody. Now that the judiciary and the executive have left us in peace, I think we can have free and fair discussion. Honorable Law Minister in absentia, Honorable Justice Nambiar in absentia, Principal Nambiar, Advocate General, Group, President, Secretary of the Alumni Association, my distinguished friend Mr. V.K. Biran, lawyer friends, student friends, ladies and gentlemen. My wife, my partner for 43 years is here, Ami. She's been my source of inspiration and encouragement. So, Fiat Justitia Raut Kaulam. Let justice be done, though heavens fall, is the motto of Government Law College. It's so brilliant a motto. And it's after a long time I'm hearing this maxim, so it was very touching. Hats off to the Maharaja, who in 1874 thought of legal education for this beautiful state, which has a great history. Just 25 kilometers from Cochin, some of the finest excavations which have been found by the Kerala State Archaeological Society are they can't hear? Is it on?
Yes.
So you have these archaeological excavations which have taken place in, I think, since 2007, which have now shown that Kerala has a history of over 3,000 years, recorded history. It's amazing. You have a fantastic synagogue which came here in the 8th century, perhaps, when the Jews landed here, and the Hindu Maharajas gave protection to them. So this is a state which is amazingly cultured, amazingly secular. Rarely do you see today any program in the country, and I have been to many programs which begin with such beautiful rendition of bhajan, and it was very nicely sung by the young lady. So it really reflects very well on the state and its people. Malayalis, of course, have contributed immensely to the development of this country. Constituent Assembly had many members from here, and it's therefore we have had some greatest lawyers. My first brush with a Malayali judge was when Chief Justice P.S. Poti came to be appointed in Gujarat. I was a young lawyer then, and somehow he took an instant fancy to me when I first appeared in his court. And till he left, I was one of his favorite lawyers, and really enjoyed learning from him, because he was an amazing judge with fantastic sense of justice, absolutely fantastic. And when Gujarat High Court was celebrating 25 years of its setting up, he appointed me as secretary in the committee to celebrate. So it was very sweet. I really enjoyed. After that, of course, we have had many great occasions. But I must confess, today, I must owe this invitation to the Alumni Association. I am grateful to them and to Senior Mr. Biran. But what really brought me here is Junior Mr. Biran, because he has been a colleague, he's been a friend over a long time, and it is very difficult for me and my wife to ever resist his requests. So here I am before you. Saturday is not the right day to discuss a serious subject, basic structure of Indian Constitution and present day challenge. Saturday mornings, I love my weekends, and I'm sure you do too. It's a time to sit across with chai and pakoras and maybe a glass of beer. But here we are discussing a serious subject on this Saturday morning. So let's basic structure of Indian Constitution and present day challenges is a very interesting subject. You have asked me to speak on. The two are closely interrelated, especially in the present context. And now that the executive has left the hall, I can say that the reason why it has become important is that the body polity has gone down to gutter in this country. We have a situation today where political parties across the board, it has nothing to do with A or B political party, have no respect left for the Constitution. They do not follow Constitution, they do not adhere to Constitution, and they certainly have no idea of constitutional morality. They behave the way they want to behave. They have tried together, collectively, to weaken, if not destroy, every constitutional institution. Every constitutional institution is today under challenge, sadly speaking. So, it's something which we will have to debate today. The power to amend the Constitution under Article 368, which was originally 304 in the draft Constitution, is in plain language quite giving clear powers of amendment. And this is something which we must understand at the outset, that the constitutional framers gave a provision which allowed the Parliament to amend any and every provision of the Constitution. The Constituent Assembly debated this power of amendment, Article 304, on 17 September 1949 extensively. And mind you, Constituent Assembly sat for 141 days. There were 23,000 amendments suggested in the draft Constitution, and 2,374 amendments were adopted by the Constituent Assembly. You can imagine the hard work that these brilliant young men and women, not young, I would say men and women of India, led by Dr. Ambedkar, Professor Rao, and others, did to bring this great document, which I consider as pious as Bible, Quran, Gita, or Guru Granth Sahib. It's an amazing document. Question is, should it be amended or not? The debates reflect very, very different idea, far away from basic structure concept. So I must begin by telling you what the debates actually discussed. Dr. P.S. Deshmukh on that day, 17 September 1949, said that no amendment which is calculated to infringe or restrict or diminish the scope of individual rights, any rights of the person or persons with respect to property or otherwise may be permissible under this Constitution, should be allowed. And this was his amendment that he suggested in Article 304A. It was not carried, of course. But he was very clear, he feared that day, that you should have a provision which expressly says that fundamental rights are untouchable. And he said that if such amendment was brought, it would be void and ultra-virus. The amendment was not carried, but he said, that being so, being the inherent under the circumstances in which we are working, and every facility should be afforded for amending the Constitution. If you do not provide necessary outlet or safety walls for air for the storms to pass through, it is likely that the whole ship may be blown off. Mr. Brijeshwar Prasad said a referendum to amend the Constitution should be provided because it's the most democratic option and is an appeal to the people, and no democratic government can have any objection to resorting to referendum in order to resolve a deadlock. I am in favor of referendum because it cures, he says, patent defects in party government. This is very interesting. One of the members, who was a Congress party member in the Constituent Assembly, went on to the extent of saying that Constitution is a Congress document and therefore it is not reflective of people's will, and therefore there must be a provision for amendment. I mean, the amount of freedom that they had in debating in the assembly was outstanding. I mean, imagine today a member of a party saying something like this on the floor of the parliament or assembly. He would be next day issued a notice by the whip as to why did you do that. But this is how they were. They were great men. Brijeshwar Prasad quotes Professor Dicey, who justifies, power to amend constitution in these words, and I quote Dicey: "Trust in elected legislative bodies is, as already noted, dying out under every form of popular government." Just imagine, this is what Professor Dicey said in the 40s or maybe late 30s. The party machine is regarded with suspicion and often with detestation by public spirited citizens of United States. Coalitions, and that's the situation here today in India, coalitions, long rolling and parliamentary intrigue are in England diminishing the moral and political faith in the House of Commons. Some means must, many Englishmen believe, be found for diminution of evils that are under large electorate, the natural, if not necessary, outcome of our party system. The obvious corrective is to confer upon people a veto which may restrict the unbounded power of a parliamentary majority. So this was the fear expressed by Professor Dicey, that a majoritarian party can do anything with constitution, constitutional ethos and constitutional morality. Brijeshwar Prasad cites an example from Dicey to support for amendment, provision for amendment. Very beautiful example. The best plea for coup d'etat in 1851 in France was that while the French people wished for the re-election of president, the article of constitution requiring a majority of 3/4 of the legislative assembly in order to alter the law which made president's re-election impossible thwarts the will of the sovereign people. Had the Republican Assembly been a sovereign parliament, Louis Napoleon would have lacked the plea which seemed to justify as well as some of the motives which tempted him to commit the crime on 2nd December. Now just see this. He gives an example that if there was a provision for amendment in constitution, the revolution wouldn't have taken place. One of the means of amending a constitution is revolution, besides referendum. But revolution is not to be accepted because that's really a very violent means. Clearly, Napoleon would not have done what he did if the French constitution had a provision for amending the constitution. Sri Kamath, H.V. Kamath, supported the provision for amendment on the ground that Constituent Assembly was elected on restrictive franchise and then indirectly by provincial assemblies on separate electorate, vitiating the assembly ab initio. Look at the humility of these men and women. They say that we must give power of amendment because we are not a legitimate body. We are not elected by people at large. We are only elected by a limited franchise. Look at their humility. Look at their way of telling future generations of India why you should have the power to amend. What happens thereafter we'll see. But this is how they discuss. Mr. Mahavir Tyagi said, the maxim on which it is based is the whole conception of democratic society today. The maxim is that earth belongs in usufruct to all living equally, and the dead have neither the powers nor the rights over it. So the Constituent Assembly members felt that we are going to die. We have therefore no right to say that this is the final document, we will live with it or die with it. He therefore said, from this maxim it is construed that a generation is disabled morally to bind its succeeding generations, either by inflicting on them a debt or a constitution which is not alterable. Dr. Ambedkar responded to these interventions by stating that Irish, Swiss, Australian, English and United States Constitution in different ways provided for amendment. He called Constitution a fundamental document, defining the position and powers of three organs of the state, the executive, the judiciary and the legislature, as also the powers of the executive and the legislature against citizens who have been conferred with fundamental rights. He said that purpose of constitution was not merely to create these legal organs, but to limit their authority. Because if no limitation was imposed, this is what he said, there will be complete tyranny and complete oppression. Now look at the prophecy of this man. He said the parliament will be free to pass any law. Judiciary will be free to interpret any way the constitution it likes. And the executive will be free to do whatever it wants to do. He didn't want that. Ambedkar was very clear. He then justified the power of amendment, stating, so far as this matter is concerned, it seems to me that a modern constitution can proceed only on two bases. One basis, to have a parliamentary system of government. The other basis, to have a totalitarian or dictatorial form of government. If we agree that our constitution must not be a dictatorship, but must be a constitution on which there is parliamentary democracy, where government is all the time unveiled, so to say, on its trial, responsible to the people, responsible to the judiciary, then I have no hesitation in saying that principles embodied in this constitution are as good, if not better, than the principles embodied in any other parliamentary constitution. So Ambedkar and his colleagues were very clear in their mind that constitution must have a provision for amendment. And this is how they proceeded. But it is with a caveat. They felt that we are not really truly representative of Indian people. We therefore don't have right to impose ourselves on the future generations of India. Let them have the right to decide what they want, what kind of a constitution they want. It must be an evolving document, it's an organic document. This is how they felt. In his closing speech on 25th September 1949, and I would tell the students to read that speech word by word. Every word that Dr. Ambedkar spoke on 25th November 1949 is to be written in golden letters. I have never seen a speech more prophetic than that of anybody in our country. Everything that's happening today, he feared that day. And I'll read that at the end of my speech, how prophetic this man was, what a vision he had, that 75 years ago this is what is going to happen to India, and that India is going to be systematically decimated by constitutional powers. That man was amazing. Please do find time and read it. He said, we may consider each generation as a distinct nation, with a right by the will of the majority to bind themselves, but none to bind the succeeding generation, more than the inhabitants of any other country. This is how he felt. Ambedkar further said, I admit that what Jefferson has said is not merely true, but it is absolutely true. He was quoting Jefferson. Those words were of Thomas Jefferson, who was responsible for American Constitution's draft. These words, which I just read, we may consider each generation as a distinct nation with a right, but the will of the majority to bind themselves, but none to bind the succeeding generation more than the inhabitants of another country. Ambedkar says, I admit that what Jefferson has said is not merely true, but it is absolutely true. There can be no question about it. He believed that Assembly has not only refrained from putting a seal of finality and infallibility upon this Constitution, but by denying to the people the right to amend the Constitution, as in Canada, or by making amendment of the Constitution subject to fulfillment of extraordinary terms and conditions, as in America and Australia, but has provided a most facile procedure for amending the Constitution. So Article 304, which is 368 now, according to Ambedkar, was one of the most easy way of amending the Constitution, unlike many constitutions in the world. Clearly, the Constituent Assembly deliberated on provision of amending Constitution and consciously provided for the same. On the salutary provision, it had no moral authority to bind future generation of India, and under a rigid document, however good or bad it might have been. Constituent Assembly was humble, and that's why it did so. So far so good. For first 3 decades, two particularly, 50s and 60s, The Supreme Court of India rigorously followed this principle that Parliament has absolute right to amend the Constitution, any provision of the Constitution, including the fundamental rights. Many judgments came in the early 60s, 50s and 60s. Shankari Prasad versus Union of India, 1951 Supreme Court. Then came Sajan Singh versus Rajasthan, 1965 Supreme Court. And then came, of course, these judgments clearly defined what it was. Then came Golaknath versus Punjab. For the first time, Supreme Court took the view that though Article 368 provides no exception as to amendment, the fundamental rights in Part 3 cannot by very nature be subject to process of amendment, and if such rights have to be amended, a new constituent assembly must be convened for making constitution or radically changing it. So 1967 is for the first time Supreme Court speaks very clearly, emphatically, and says that yes, Parliament has a right to amend, but it doesn't have right to tinker with the fundamental rights. If they want to do it, there must be a new constituent assembly. A lot of legal thinkers worldwide have said that constitution can be materially altered only by a new constituent assembly. In India, we made the effort, I think, when Mr. Vajpayee's government was there, Chief Justice Venkatachalaya Commission was appointed to review the working of the constitution, and it did submit the report, but I don't think that report has subsequently since been adopted or acted upon by any government. Mrs. Gandhi's government did not like Golaknath's judgment, naturally, and brought the Constitution 24th Amendment 1971, inserting sub-article 4 in Article 13. Article 13 of the Constitution has a very interesting provision. Very rarely it's been positively interpreted. It says that fundamental rights in Part 3, and Article 13 is part of Part 3 of the Constitution. If any law is brought, any order is issued, any notification is issued, which violates fundamental rights, then that law, that notification, that order would be void. That's a deeming provision that constituent framers provided in Article 13. So to overcome that, Mrs. Gandhi brings 24th Amendment 1971, inserts sub-article 4 in Article 13, which excludes amendment of the Constitution from the purview of Article 13. And she brought a clause 1 in Article 368. The effect was that amendment of the Constitution would not be law within the meaning of Article 13, and thereby it would not be open to question on the ground that it takes away or affects the fundamental rights. So virtually judicial review was taken away so far as amendment of Constitution was concerned. Then came the judgment of the Supreme Court, the famous Keshwanand Bharti versus State of Kerala in 1973. The ratio of this judgment is impossible to decipher because the bench of 13 judges, every judge has given a separate opinion, and even with great difficulty I have not been able to understand what their ratio was. But they did for the first time provide for basic structure theory. And interestingly, in providing basic structure theory, they excluded fundamental rights from it, which is very shocking. Because if fundamental rights are not basic structure, then I don't think there is any other part of Constitution which should be treated to be a basic structure. Because ultimately, what are fundamental rights? These are basic human values. And these basic human values have to be protected, have to be held to be unalterable. These values are God gifted. They are not fundamental because the constitutional framers treated them as fundamental. They are fundamental because they are fundamental to human living, to humanity, to every society. No society can survive if these basic values, freedom of speech, freedom of expression, civil liberties, right to move freely, freedom of press, all these, right to do business, all these rights are basic human rights. So in Keshwanand Bharti, the basic structure theory comes for the first time, but sadly the judges exclude fundamental rights from the principles of basic structure. To overcome this judgment, Mrs. Gandhi brought the 42nd Amendment. So this is, you realize now why it is necessary that the Supreme Court had to intervene and adopt this basic structure theory. Why is it important for judiciary to act today much stronger than what it has? Because these, majoritarian parties, be it Congress under Mrs. Gandhi then, or be it present government under Mr. Modi, they can bring any law and have it passed simply because they have brute majority in the parliament. That may include constitutional amendments. And one of the reasons, and Honorable Mr. Vice President, Mr. Dhankar, eminent lawyer and a good friend, the other day suggested that Keshwanand Bharti requires to be reconsidered. And I did write a couple of months ago in Hindu, saying that perhaps he is professing or he has an idea of a presidential form of government in this country. Because there is no other reason why he would want to talk about basic structure theory to be removed. So, you don't know what exactly the political thought is about. The people's will and political thought are completely at crossroads, at cross purposes. And the political parties, once they get elected, are never bothered about the thoughts of the people who elect them. In any case, every political party which has a majority only gets elected with 1/3 of the votes of the country. It's never more than that. Out of 130 crore population, I think we have about 80-85 crore people voting. And out of them, 65% voted. And out of that 65%, 37% supported Bharatiya Janata Party. Therefore, effectively, 25 to 30 crore people voted for Mr. Modi's policies. And yet, he would speak for the nation and would try and do what Mrs. Gandhi did, fortunately unsuccessfully, thanks to a very strong Supreme Court at that point of time. Now, what was the effect of Keshwanand Bharti? That Chief Justice Ray superseded 3 good judges, Hegde, Shelat and Vaidhalingam, I think. 3 of them. And Grover. And they resigned. So, this is what happens. But judiciary should be ready for this confrontation. It should be ready to make sacrifices. I'm not sure whether today's judiciary is ready for that. But these were the judges who were at that point of time. So this is how the development took place over a period of time. The doctrine of basic structure has now become an axiom. It's premised on the basis that invasion of certain freedoms may be justified. For example, if freedom is related to cases of terrorism. The Supreme Court held in Coelho versus Tamil Nadu, a 2007 judgment, very beautifully written by Chief Justice Sabharwal, that application of a standard is an important exercise to be undertaken by court in applying basic structure doctrine. It was also held in this case that power of Parliament to amend constitution and to make laws that exclude Part 3, including judicial review, is incompatible with basic structure doctrine. So they did make exception that terrorism is an exception. But I must say that Israeli Supreme Court, one of the finest judgments of the entire court, I think Chief Justice Barak speaking for the court, many years ago, held that the kind of practices which the Israeli army was adopting on Palestinian prisoners, including, tying their hands and legs behind their body and keeping them in that condition for a number of days, was unconstitutional. And Chief Justice Barak says that we know that Israel is facing existential crisis. But yet, if Israel were to allow violations of human rights, then it will be a saddest day, he said, for this country. Now look at the approach that Israeli Supreme Court has. Chief Justice Sabharwal makes an exception for terrorism. In the name of terrorism, we know what is happening. Thousands of young men and women have died in Jammu and Kashmir and in the Northeast under the Armed Forces Special Provisions Act, where no scrutiny is permissible, because there is a complete umbrella to the army, which as an institution I respect the most. But this umbrella today has enabled them to kill thousands of young innocent men and women. Yes, terrorism has to be fought. Nobody can say no. I am strongly of the belief that terrorism must be countered with strong measures. But there must be some supervision. We have none. Now this is how the difference in jurisprudence is. A country like Israel, which is every day facing terrorist threats, and is surrounded by enemies all across. But the Supreme Court took a very good view, and that's why Prime Minister Netanyahu, as law minister just said, is trying to do everything that's possible. It's possible to, overcome the judiciary. The basic structure concept therefore limits the amending power of the Constitution. This is the standard prescribed by judiciary to Parliament. So for the first time, judiciary has told Parliament that you have right to amend, but do not amend the Constitution so as to affect or remove the basic structure. Now what the basic structure is, we'll see. Supreme Court has a vital position under the Constitution of India and has a duty to interpret and decide if the laws, including the constitutional amendments made by Parliament, are ultra vires or not. Judicial review is itself the basic feature of the Constitution. This being the position, it cannot be argued, as is being suggested in some political quarters, that Supreme Court cannot do what it has done. Mrs. Gandhi tried to undo the basic structure theory by the 42nd Amendment and failed. Yet in fundamental philosophy, that fundamental rights are justifiable and they contain values imposing a positive duty on the state to ensure their attainment to the fullest is really the principle. It is universally accepted that rights, liberties and freedom of individual are not only to be protected against the state, but should be sufficiently facilitated, and that citizens must be duly informed about them. In this country, it's, I must say, and as a lawyer I take the responsibility, and law colleges also equally must take the responsibility, that our citizens are not aware of their fundamental rights. They are certainly not aware of their constitutional rights. And that's the reason why the state and the police can act as they do, from time to time against the citizens. Human dignity is the cornerstone of this doctrine. Human dignity is the cornerstone of this doctrine. The right to life, even under Article 21, is not merely physical or animal existence, but includes the right to live with dignity. State must take positive steps to protect these rights. This theory is based on the concept of constitutional identity. So Constitution's identity really are these values, these fundamental rights, and that's very, very important. As the Supreme Court has observed, one cannot legally use the Constitution to destroy it. And that personality of the Constitution must remain unchanged. In Coelho, Supreme Court says this, very beautiful words. How does the court determine if a particular feature of Constitution is a part of basic structure? The test to be applied as held in Question and Bharti, Minerva Mills and Nagaraj cases is that one has to perforce examine in each individual case the place of the particular feature in the scheme of our Constitution, its object and purpose, and the consequences of its denial on integrity of the Constitution as a fundamental institution of country's governance. Now if you apply this test, secularism, fundamental rights, parliamentary democracy, judicial review, independence of judiciary, these are amongst the many concepts which become basic features of the Constitution. Without them, Constitution will have no life. It will be a dead letter. It will be a document which is of no use to the nation. The Supreme Court has declared multitude of features as basic, including supremacy of Constitution, rule of law, principle of separation of powers, preamble, judicial review under Article 32 and 226, federalism, secularism, sovereign democratic republic structure, freedom of individual, fundamental rights, parliamentary system of government, independence of judiciary, and access to justice among them. These are all basic features of the Constitution. If you think about them, you will agree that each of these features is so important for us as a nation. Constitution is like a moral code that every family has. Every family expects that the members will observe certain code of conduct. They will behave in a particular way. And the moment one member tries to break that code of conduct, the moral code of conduct, then the family withers away. Now that's exactly what the nation is about. It's one big family. And constitution is a moral code of conduct. Everybody must adhere to it. And if people or a group of people start veering away from it, tearing away from it, then naturally the very fabric of the country will get destroyed. And this is why it is important that all these functions or all these features must be. Even multi-party system in a parliamentary democracy is an inherent part of basic structure, as was held in Kuldeep Nair versus Union of India. Look at the situation today. Today the situation is such where, Prime Minister Modi once said, and he said it to the press, so I can repeat it, that we want Congress Mukt Bharat. Today, I think what BJP wants is an opposition Mukt Bharat. Now, can any country survive without opposition? In fact, during the Constituent Assembly debate, one member went to the extent of saying that if opposition is not allowed to exist, it will be an act of sedition on the part of party in power. Act of sedition. He says he will be a traitor. Now, multi-party system is the basic feature of our constitution. You cannot destroy that by using agencies like CBI, ED, income tax and other agencies. And that's exactly what is happening today. That is why it's important for us to understand why basic feature theory is so important for our day-to-day living, our day-to-day life. Ambedkar had feared long back. On 25th November 1949, in his last speech, he says that will India lose democracy? And he answers the rhetorical question by saying, yes, if there is a landslide, meaning election, as BJP has now and Mrs. Gandhi had, if there is a landslide, there is every possibility that India will lose democracy in fact, but will retain it in form. So we are today a democracy in form. There is no democracy in fact. The targeted attacks on critics, on stand-up comedians, targeted attacks on minority community, targeted attacks on opposition. What do all these reflect today? That today's India is really undergoing a massive challenge which is so difficult to overcome because our people are not conscious about their rights. As the minister speaks about Israel, look at Israel. 100,000 people protested in Jerusalem against Prime Minister Netanyahu's new reforms to say the reforms are threefold. He says that Supreme Court law we can overturn in Parliament. 2, Supreme Court, if it wants to declare any law unconstitutional, all 15 judges must agree. Even if one dissents, it's not a judgment. And 3, that we must have right to appoint judges to Supreme Court and higher judiciary. Now, people are so incensed by it that thousands of people are protesting in other cities. Israel's best industry is technology industry. The technology industry has threatened Prime Minister that we will move out of Israel and go to Europe. Now look at our country. The minister speaks about, that there is no voice. But it's the political parties. What do they do? What are the irrelevant issues that they raise today? Do they not think that this is important? That these attacks which are taking place on judiciary day in, day out, where the minister goes on attacking judges after judges, the vice president attacks, the Lok Sabha speaker attacks. Why should the political parties not carry out demonstrations and popularize constitutional morality? But they are only interested in their power and absolute power across the board. There is no political party which is free from this. Every political party, unfortunately, only lives for its existence, not for the people. So this is where we have a responsibility as lawyers, law students, and law teachers to take the message to the people across the country that there is a fundamental document. It is as to be revered as much as your own scripture. Maybe Quran, maybe Gita, maybe Bible, maybe Guru Granth Sahib, maybe anything. But you must therefore respect Constitution as much. But that message is not percolating down to the people at large. And that's why the politicians can get away. That's why they have been getting away for all these years. The test applied in this regard is the width test and the test of identity, to identify basic features. The former being bound with the width of the power and the latter being no alteration in the existing structure. Constitutions world over have been amended either through modes of revolution, referendum, or amendment by parliament converting itself into a constituent assembly. But while revolution is out of question and the referendum is not recognized in our constitution, the third option of parliament becoming constituent assembly is rejected by Indian Supreme Court. The question then arises, how does and why did the Supreme Court go against the wishes of the constitutional framers in propounding the theory of basic structure to limit the power of the parliament to amend the constitution? I think the judges were very, very right in not allowing the parliament to do what it wants to do, irrespective of what the constitution is. Yes, constitutional framers wanted parliament to have power, clear power, unbridled power to amend the constitution. But the judges saw what the body politic had become. And once they realized that we must put a check on this kind of amendments, the amending power of the constitution, because if constitution is amended as politicians want it to be amended to suit their conveniences against the people, we the people, then nothing will survive of democracy in this country. And that is how the judges acted. They reacted. And I must say that that's the reason why judiciary is respected so much today in the country. That it is the judiciary which alone can stand between a powerful executive, a majoritarian parliament, and the people of the country on the other side. We can only be defended by the judiciary. No, there is no other means to defend us. And that's what judiciary has done so far, and done it very well. Yes, there are sometimes issues. I am a great critic of judiciary also in many ways. But that doesn't mean judiciary's role must be diminished in any manner, or that we should not respect judiciary as we do. We must. The answer is simple. Mrs. Gandhi sought to bring about laws that were directly in conflict with fundamental rights. So long as those rights stand on the constitutional textbooks, it is but natural that the amending constitutional act would be void if it sought to infringe them. The Supreme Court therefore rightly declared sub-articles 4 and 5 to be unconstitutional. This is what they did in Minerva Mills, because Mrs. Gandhi brought by 42nd Amendment, she added sub-articles 4 and 5 in Article 368 to say that no, there will be no judicial review of a constitutional amendment, and that we can do whatever we want to. And they redefined power of amendment, saying that we can amend, we can delete, we can do everything. Supreme Court in Minerva Mills said this is unconstitutional. And since then, in series of cases, Nagaraj, Coelho, and Quixote, all these cases, Supreme Court has consistently said that no, this is untouchable. If you think that you can do it, we are here to stop you, we will stop you. So that's something which is very, very important for us to understand. India is governed by constitution, and rule of law is one of its most important features. Parliamentary democracy is another feature. Judicial review and independence of judiciary is equally important, and so are the fundamental rights of us, we the people. Therefore, any attempt to tinker with these provisions would make the constitution redundant. It would never have been in contemplation of constitutional framers. Now, I must tell you one thing. When Ambedkar and his colleagues were framing the constitution, I don't think they ever thought that we are actually going to have people who will sit in parliament and take away citizens' fundamental rights. I mean, they never thought that it could happen, or that they will bring laws which directly impinge upon the fundamental rights. They never thought that, because they were perhaps naive. They were good people. They could never think of bad people in public life. So, but yet, the Ambedkar does give a warning, and Ambedkar says, this warning is very interesting. Ambedkar says in his speech, will history repeat itself? He says, will India lose democracy? Will history, he says, in the past we have lost democracy. He says, will history repeat itself? It is this thought which fills me with anxiety. This anxiety is deepened by realization of the fact that in addition to our old enemies, in the form of caste and creed, we are going to have many political parties with diverse and opposing political creeds. Will Indian place the country above their creed, or will they place creed above country? Look at this warning. I do not know, but this much is certain, that if the parties place creed above country, our independence will be put in jeopardy by a second time and probably be lost forever. This eventuality we must all resolutely guard against. We must be determined to defend our independence with the last drop of our blood. This is what Ambedkar says. And today's political parties don't even put India beyond their political ideology. They are only about party whip, party's principles, party's policies, however much unconstitutional and wrong they may be, however much they may be against the interests of we the people. They don't want to put it beyond that. They close their eyes. The moment message comes from Shri Amit Shah, every member of parliament sits there and signs on a dotted line. The farm laws were passed without a debate, and the farm laws were repealed without a debate. Look at the irony. Is it conceivable that any parliament can pass laws without a debate? That's precisely what is happening today. You look at any act which is passed by parliament in last 8 years, you hardly find any debate. Open up any All India reporter, AIR, of the 50s, 60s and 70s, and you will find that whenever laws, particularly legal provisions, are amended, there will be fantastic debate, member after member will contribute to it. So it's something which is very, very, shocking that's happening. Ambedkar said 3 things, and I wish to quote that. He says, as I said, he said about landslide, but then he says, if we wish to maintain democracy, not merely in form, but also in fact, what must we do? The first thing in my judgment we must do is to hold fast to constitutional methods of achieving our social and economic objectives. It means we must abandon the bloody methods of revolution, he says. Second thing he says we must do is to observe the caution of John Stuart Mill, which is given to all those who are interested in maintenance of democracy, namely, not to lay their liberties at the feet of even a great man, or to trust him with powers which enable him to subvert the constitution. Exactly what we are doing. He said that bhakti in politics is most prevalent in India. In 1949 he says that, because he did not perhaps like people worshipping Gandhiji and Jawaharlal Nehru. So he says bhakti in politics is most prevalent in India. He says bhakti is good for salvation of soul, but he says bhakti in politics is a sure path to dictatorship. And that's precisely what's happening today. Bhakti. We see all the bhakts around. I mean, the kind of worshipping that they do is mind-blowing. So Ambedkar warned us that. The third thing we must do is not to be content with mere political democracy. Look at our political class today. We must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at the base of it social democracy. What does social democracy mean? He questions. He says, it means a way of life which recognizes liberty, equality, and fraternity as the principles of life. These principles of liberty, equality, and fraternity are not to be treated as separate, but as a trinity. They form a union of trinity in the sense to divorce one from the other is to defeat the very purpose of democracy. So to him, liberty, equality, and fraternity. Look at fraternity. Look at the polarization in the country. Where is fraternity today? Is there fraternity amongst the high caste and the low caste? Is there fraternity amongst religions? Kind of society that you have in Kerala, every Indian must be proud of. We don't have that kind of a situation in Gujarat, where I come from. There is complete polarization in Gujarat today. Now, Ambedkar said that it will destroy democracy if you don't have fraternity. And fraternity is part of preamble of the Constitution. Very few people know that. Liberty, equality. Are we equal? The gap between rich and poor is widening every year. I think the nation is content with having Ambanis and Adanis. Now, do we want that kind of a society? Of course we must have industry. I respect industry. I'm a hardcore capitalist in my heart. I'm a socialist by action. But I'm a hardcore capitalist because I do believe that you cannot kill enterprise of people. You cannot kill enterprise of people. And communism or socialism, which we thought of, really killed enterprise of Indians. Since we have unshackled in the 90s under the leadership of Mr. Manmohan Singh, Narasimha Rao and Manmohan Singh, we have had really, this country is now going, we are the 5th largest economy in the world. And rightly so. How are we going to feed 130 crore people if we don't have industry along with agriculture? So it's very important. So liberty, equality and fraternity is Ambedkar's message to all of us, and that's something which we must really... Ambedkar closes this by saying that independence is no doubt a matter of joy, but let us not forget that this independence has thrown on us great responsibilities. By independence, we have lost the excuse of blaming the British for anything going wrong. If hereafter things go wrong, we will have nobody to blame except ourselves. Look at it. He says we have to blame ourselves, and rightly so. There is great danger of things going wrong. Times are fast changing. People, including our own, are being moved by new ideologies. These are his last words. New ideologies. Fascism. They are getting tired of government by the people. They are prepared to have government for the people. Our political class has governments for their friends, their families, for them. In more than one case, we have seen that. So Ambedkar warned that they are prepared to have government for the people and are indifferent whether it is a government of the people and by the people. If we wish to preserve the Constitution in which we have sought to enshrine the principle of government of the people, for the people and by the people, let us resolve not to be tardy in the recognition of the evils that lie across our path and which induce people to prefer government for the people to the government by the people, nor to be weak in our initiative to remove them. This is the only way to serve the country. I know of no better, he said. These are his last words. So, ladies and gentlemen, I must say that the constitutional principles must remain, intact. You cannot allow the political parties, simply because they have majority, to do what they want to do. And that's why Supreme Court has evolved this brilliant concept of basic structure. It is an innovation. And it is a path-breaking innovation that Supreme Court has made. Innovation in the right sense. Our Supreme Court has contributed jurisprudence greatly. For example, administrative law, judicial review of administrative actions. It started in England. But Indian courts have taken it to different heights. Our interpretation of Article 21, right to life. The Supreme Court says right to life is not just some animal life, but life in the true sense. Dignity, right to education, right to housing, right to clothing, right to food. All kinds of rights Supreme Court has brought into Article 21 to make life very meaningful. So this is how the court has really done what exactly. So in my view, looking to what has happened in the country since Mrs. Gandhi came into power in and what she started doing after 1971, which led from time to time to executive or parliament passing constitutional amendments which were direct inroads into fundamental rights. The basic structure theory has served us well, and it is here to stay for a long, long time. We as people must make sure that this basic structure theory is known to the people of the country, what great contribution the Supreme Court has made, how it is protecting us today, how our liberty is safe in the hands of this law, how this law is really, looking after us, looking after our welfare. So this is something which we must important. This is why the basic structure theory is important. And as the present day challenges which we all saw, which I briefly discussed, but we see all the time, I mean, in the newspapers, the challenges coming, the kind of challenges that our political class thrusts on us, the people, on a day-to-day basis, on our opposition parties, which is our viewpoint, on our, critics, on our, other leading objectors to the government. Anybody government doesn't like, they are visited with all kinds of challenges. So in these challenges, in today's times, please realize that things are really going from worse to worse. It's not bad to bad. Things are going from worse to worse. And we are not governed in the right sense today. The governance is at its lowest ebb in this country today. Lowest ebb. Rule of law has become merely on paper. There is no rule of law. Look at this. I mean, a witness was killed in UP in a very serious murder case. It was wrong. The persons who killed witness have done a great crime. They should be brought to book and they should be given maximum punishment. But it's important to give punishment in such a way that, he will live to live that punishment. So give him life imprisonment for full life to make sure that every day of his rest of 30, 40 years, he remains in prison and realizes that what he did is wrong. Now what do? We pick up those alleged accused without bringing them before judiciary and start killing them. We demolish their homes. Is this the kind of rule of law that constitutional framers wanted? This is a challenge today. You find in Delhi some locality where certain homes are constructed maybe unauthorizedly. And you start demolition. Because why? Because members of minority communities stay there. Now Delhi has some 600 colonies, admittedly, which are unauthorized. Some of them on government lands. And government has said so on affidavit in High Court and Supreme Court about this. One of the most well-known colonies, Sainik Farms, where the rich of Delhi live. You don't touch them, but you want to touch these poor people's homes only for certain political compulsions. Now this is not the rule of law. It is breaking down in many forms. Federalism is under challenge. Today GST collection is being done. GST is a compromise by the states in favor of the center, so that center could collect 1 point tax and distribute it to the states. That was the understanding. Prime Minister Modi, as Chief Minister of Gujarat, for 10 years resisted GST, and in one letter went on to the extent of saying, over my dead body. But then when he becomes Prime Minister, he launches GST in the middle of the night, makes President Pranab Mukherjee also stand up and I think inaugurate that GST. But today what is happening? Chief Minister after Chief Minister is telling us that the state's dues are not being paid for months and months on. Now how do states survive then? The only source of income left to the states is alcohol. So what is happening today? States after states are pushing sales of alcohol in the country, which is not good for us. So this is how federalism is being killed. 8 state governments have been dismissed by luring away the MLAs. The Supreme Court says the test is only floor test. Now these MLAs have already been 1 over 20 or 30 of them. They are taken in a chartered plane. They go and stay in a 7-star hotel in a BJP ruled state. And then they are brought on the day of voting. What are they going to vote? They are going to vote against the party on whose ticket they got elected. Now is this the floor test that we really wanted? Is this rule of law? So we are using constitutional methods to destroy democracy. These are some of the examples. So we all have to think, each one of us has a responsibility and duty to the Constitution of India. And I beg you to really perform that duty on a daily basis. Thank you very, very much.
Thank you, sir, for the edifying lecture, taking us through the evolution of the ground norm, since the Constitutional Assembly to its present condition and the essence of the basic structure. Now the floor is open for an interactive session. If you have any questions, comments or points to put across, kindly raise your hand and I'll bring the mic to you. Okay, I'll go there first.
Sir, as you said rightly, the Constitution and the rule of law, federalism, everything we cherish is under threat. You being from the legal community, being a prominent lawyer, don't you think our judiciary, the supposedly the protectors of the Constitution and the people, are they not responsible for this deteriorated condition? Judging from the funny judgment of Babri Masjid issue, which is not even signed by the person, by the judge who has written it, that is called a funny judgment, because without any authorship, real authorship. So, is judiciary not responsible for this deteriorated condition? That is my question. Like Babri Masjid essentially is a dispute, legally seen. I would like to hear your comments.
Hello. Yeah. Thank you for your question. Yes, judiciary is greatly responsible for what is happening today in the country. I have no doubt in my mind. And judges have failed us in last few years in more than one way in protecting the Constitution, the constitutional morality, the constitutional ethos, the constitutional provisions in many, many cases. And I do believe genuinely, forget, I don't know the rights and wrongs of the Babri Masjid judgment, but I must say one thing, that the era under Chief Justice Gogoi, who was completely compromised on account of his involvement in a sexual harassment case. I think his leadership was perhaps used to its advantage by the executive in getting judgments after judgments in favor of the government, be it Ayodhya, be it Rafael case, be it removal of the CBI director and other cases. So I don't think in any country, just for a day, it's an insult to 75 crore women of India that such a judge could continue to be a Chief Justice of this country. And I have interacted with that lady who suffered at his hands and her husband. And I can tell you, her complaint was absolutely genuine. It was not a bogus complaint. And Supreme Court, I must say, some of the good judges, I won't name them today, some of them have been my friends, but some of the good judges were party to protecting Gogoi to the extent that they sat on a bench on Saturday to declare, where Gogoi presided, saying that this was a conspiracy against him. And Solicitor General moved a public interest litigation, and Chief Justice Gogoi himself appeared on that bench on Saturday morning to claim innocence and said all kinds of accusations against the lady who was unprotected. And then the Supreme Court, under leadership of great Justice Arun Mishra, sat on a bench and said that we must unravel this conspiracy against the Supreme Court to defame it and appoint Justice Patnaik as a committee, and Intelligence Bureau, RAW, CBI, everybody must assist. I was surprised why didn't they ask CIA and KGB also to assist them. But they asked everybody to assist that committee to unearth this conspiracy. The report was given by Justice Patnaik to Supreme Court, and Supreme Court quietly buried that report, Justice Kaul's bench. So I personally feel that the era under Justice Gogoi, like many Chief Justices in recent past, I have publicly said that the leadership of Chief Justice Mishra, Chief Justice Kher, Chief Justice Gogoi, Chief Justice Bobde and Chief Justice Ramana have really created great damage to the institution of judiciary. And as a result, citizens have suffered immensely in many civil liberty cases, many other cases. and convenient judgments, not just to the executive, but even to business, giants, have been given by the Supreme Court to suit their convenience. Yes, it has been I would say, it has been a matter of great personal disappointment to me as well.
Hello, sir. My name is Afif. And there should be a constructive amendment for the part 3 in the Constitution. So my question is, if your argument is accepted that the fundamental rights should be made part of the basic structure, would that act as a factor in the constructive amendment of part 3 fundamental rights?
No, I think I wasn't, perhaps maybe I was not clear. Following Minerva Mills, Coelho, Nagaraj, all these judgments, now law is very clear that fundamental rights are basic structure, and therefore government will not be able to amend the constitution to tinker with the fundamental rights. Yes, Article 13(4) still survives, and that's a matter of concern, because surprisingly that was not set aside in Minerva Mills. But even then, the Supreme Court is consistently holding many laws to be unconstitutional. In fact, in Coelho's case, all those laws which were placed under the 9th schedule to give complete umbrella of protection, they were also declared to be unconstitutional. Supreme Court said that they violate fundamental rights, and therefore even constitutional immunity will not come in the way. So I think as the law stands today, it's sufficient, provided the law is implemented in letter and spirit. In many a times, judges themselves fail to implement their own law. They don't follow their own judgments and go ahead and give judgments which are case-to-case basis. There is I would say there is complete consistency in inconsistency in Supreme Court judgments, and that's a matter of great trouble, great concern in the.
Thank you, sir.
Sir, I am Advocate Lakshmi Narayan, practicing lawyer at the High Court. Sir, I understood that I used to hear all your lectures coming through YouTube and all that. I am a great fan of yours. My question is this. You are not in favor of the proposition that the executive must play any role in the appointment of judges, High Court level, Supreme Court level. But you are not in favor of the collegium also. What should be the via media, sir, for a best selection of judges? For independent judiciary, selection of the judges is the most relevant criteria. That is my question.
See, you are right. I mean, I in fact argued when NJSC was challenged as president of the Supreme Court Bar Association, and I told judges that collegium system is bad, because I gave examples after example. In fact, my own view is that some of the most questionable judges have been appointed in the era of collegium system. And prior thereto, there may have been few bad judges, but they were far and few when executive was appointing them. But today the problem is different. Today the executive has, a philosophy, has an ideology, has an agenda, has a program to ensure that the judiciary is weakened from within. And every other institution, look at the Controller of Auditor General, look at Reserve Bank of India. I mean, can you imagine that you can bring demonetization without prior consent of Reserve Bank of India? It must start from there. The process was reversed. Government suggested, Reserve Board, Bank of India board met, passed quickly resolution, board resolution. I don't know whether what they considered, nobody knows that. And government within hours, 2 hours, brought the law. So every institution is today suffering. The answer to your question is very difficult, unfortunately, in today's present day India. We have somehow lost our moral fiber. And it is therefore impossible to find people who can man positions of, I would say, eminence, position of importance, position of power, position of, doing something for citizens, who are really, truly judicious, who are truly independent. That kind of people are not existing today. I'm not saying that everybody is bad, but by and large, who is collegium? Who are these judges? They are representatives of our society. We as a society are today unable to have that kind of moral fiber which, the generations before us had. So therefore, what do you do about it? If you can't get judges, now today what are the collegiums doing? Whether in High Court or in Supreme Court, you have experience. They do pick and, they say, yours, mine, are two, mine is one, and this is give and take amongst the members of the collegium. They don't objectively do what exactly, see, they grabbed the power in 93 second judge's case judgment and said, we will select the best from amongst those available. These words are important. Best from those amongst available. Now when you have to appoint a judge in High Court of Kerala, you have to find who are the best people available amongst the legal fraternity, amongst the teaching faculty, because the jurists can also be appointed. We rarely consider jurists for appointment as High Court judges or Supreme Court judges. The constitutional framers wanted them. In countries like Europe and America, many professors are considered for high judgeship. We don't consider them. We don't give them due respect. Now, and in the kind of attributes that these people have, today it's very easily, my own experience is, in last 8 years particularly, the kind of judges who are being considered is because they have certain bent of ideology. Who is selecting them? The collegiums. And who is finally appointing them? The Supreme Court collegium. They don't ask anybody. They don't ask any advocate general properly. They don't ask any senior lawyers. They should ask 5-7 senior lawyers privately. That what do you think about Mr. X or Y or Z? Nothing of that kind. So it is, the whole process has seriously, I would say, degenerated into picking people whom they personally think are people who should be appointed. And they are more than often, I would say, themselves influenced by political ideology today, the collegium members. So we are not getting the best from amongst those available. I don't disrespect judges. I love judges, and I do believe that there are still many good judges across the country. But it's not the good judges who worry me. It is few bad judges who worry me a lot. And that's something which we have to now, I don't know, we will never be able to reverse that situation for next 15-20 years. So I think we have lost the plot.
Sir, I am Advocate George Zakaria, practicing in the High Court here. Actually, I am thankful to you for a very elaborate lecture on the moral principles which the Constitution or Constitution bears. And I was very happy to hear that even you were quoting J.S. Mill as well as, without naming, I think you are quoting the social contract theory of Rousseau also. And while coming to my anguish and apprehension, you are saying that there is a very chance for an interference by the judiciary over the executive or even legislative autocratic actions. In such a situation, my only question is, nowadays what we see in reality is, if judiciary interferes, then the question or criticism comes in the way of saying that it is judicial activism. So how can we counter this kind of a criticism against judiciary if it acts rightly and genuinely?
Look, the executive hates judiciary. You must understand, political class dislikes judiciary. And therefore, anything that judiciary does to stop them from their adventures, they are bound to say that judiciary is proactive. Of course, sometimes judiciary is proactive, undoubtedly. But why does it act proactively? To fill the void created by the executive at the parliament. Take for example Vishakha's case. For the first time it was Supreme Court which came up with the judgment and said that sexual harassment of women in their offices and workplaces must be stopped. Our great parliamentarians never thought about it. And we all know what kind of exploitation goes on in offices of our women. So, I mean, you have to understand that political class is not going to like this. And media is at their beck and call. Media never wants to serve the constitution or India. The media is highly politicized. Most of the media, highly politicized. And they are only serving different political ideologies. And the media is virtually owned in India by the rich people, And these rich people are only interested in making money. Why do you think today you see in every newspaper, first 2 pages as advertisements of various political parties? When we were young, did we ever see that kind of advertisement? We used to love opening the first page and read some good news. Today we see face of Mr. Modi or Mr. Jagan or Mr. K.C. Rao or Mr. Stalin for first 2 days. I mean, is that what we are supposed to see? So why do they do that? They are indirectly bribing the media at the cost of us. Public exchequer pays for these advertisements. It's your money and my money. It's a complete waste. But it is being done to silence the media into submission. So, I am not worried about this criticism. Let them go on criticizing. Judiciary will do what it has to do, and I have no doubt these few good judges, or many good judges, I must say, will continue to really stand up for the Constitution and stand up for the people of India.
Good afternoon, sir. My name is Harishankar and I'm a 4th year student of Government Law College. So my question is that you, in your statement, had mentioned that the public image of judiciary has fallen by a very large extent in the past few years. And as a common man is concerned, the judiciary acts as a last resort when it comes to constitutional interpretation. So my question is, what is, in your opinion, are the steps, or what are the steps by which the judiciary can detoxify itself and the Constitution?
I don't think I said that public image of judiciary has fallen in last few years. I think I was misunderstood by you. On the contrary, I said judiciary has done remarkable work by bringing the basic theory principle. Yes, judiciary is under challenge from within. The judiciary is unable to really do what it should do, play its role fiercely independently, fiercely objectively. And many judges in last few years have failed us. But that does not mean failure of few judges like Chief Justice Gogoi for that matter really reflects on entire judiciary. Yes, there are instances which are sometimes extremely telling, and I constantly say, give 2 examples. One is, the arrest of famous actor Shah Rukh Khan's son. The FIR, which I read very carefully then, really said that he had no narcotics on his body, and yet he was arrested, produced before the magistrate. And magistrate, instead of releasing him straight away, he gives him police remand and extends police remand and then refuses bail. Sessions Court also refuses bail. Now these are the instances which really are telling instances which show that judiciary is failing in many cases. Again, Bhima Koregaon, for example. Even Supreme Court has refused to release these people on bail where there is a case. That journalist from Kerala who went to cover Hathras case, he ended up spending 2 years in jail for what? There are instances. Take for example this Kerala girl who married a Muslim boy. Adia. Now that was a classic example where Supreme Court made I would say, complete fool of itself by ordering NIA investigation. For what? For love marriage. I mean, is that the job of Supreme Court, that love should be criminalized? So, there are instances, again and again they are happening. But those are judges who should be, singled out and attacked. But judiciary as a whole is an institution which we should all be proud of. We must respect, continue to respect, and we must support it.
So my name is Indu and I'm a student at the Government Law College, Ernakulam. In your speech, you said that at the time of Mrs. Gandhi, the judiciary was strong enough to face confrontations. But in our present political climate, we see the retired judges accepting political positions like Rajya Sabha MPs, governors of state, etc. How do you view this shift in the attitude of judiciary?
No, this has been going on for a long time. There are many judges in the past. Baharul Islam, in fact, went to executive from judiciary, came back to judiciary. He was a classic. Fatima Bibi was appointed governor of Tamil Nadu, as you all know. She was a Supreme Court judge. There have been many such. Ranganath Mishra was a Rajya Sabha member. So this is, it's unfortunate that these judges occupying very high positions then fall prey to these small, kind of attractions and become Rajya Sabha members or, accept an executive post in the government. It shouldn't happen. And frankly, during Constituent Assembly debates, when independence of judiciary was discussed, they said again and again that we must make some provisions whereby judges are prohibited from accepting any position. My own view is that judges should not be allowed to do anything including arbitration, because if arbitration as an institution has failed, it's because of retired judges. They are absolutely incompetent and greedy by and large as arbitrators, and it has destroyed arbitration scene completely. So I feel that the judges must be prohibited from accepting any kind of position, and acceptance of positions by Chief Justice Gogoi is a clear case of quid pro quo. Clear case of quid pro quo. He obliged them by ensuring many judgments come. He obliged them by constituting, favorable benches so that corporate giants supporting the government get judgment after judgment. He obliged them in many ways. So they obliged him back. And then now we have Justice Nazir, who is accepted, governorship. It's a very sad thing. I have no doubt in my mind it's a quid pro quo. He was a decent gentleman. He shouldn't have done it. He shouldn't have fallen prey. He shouldn't have fallen. Very fine gentleman. So it's, what do you do? I mean, people have lost that kind of conviction, courage, and, independence. And as I said, that it's just lost from the society. I don't blame them. So it's a bad thing, I agree.
Good afternoon, sir. I am Dr. Girishankar. I am an Associate Professor at Government Law College, Ernakulam. I just have got only a pointed question, because judicial review is a basic feature of Indian Constitution. That is a settled position. And then, obviously, the democratic nature, or rather the undemocratic nature, is already been called into question. My question to you is whether there should be an alternate reading on judicial legislative process altogether, because of the tinkering that is being consistently done at the processing stage and in all conceivable forms both in the parliament as well as in the legislative assemblies.
I don't think it's impossible. Ultimately we are a parliamentary democracy and we have to accept it. And parliament does, in a sense, reflect the will of the people. And parliament, is the constituent assembly in that sense, and it's a sovereign body. So it's very difficult for us. The difficulty is that we are not able to attract good people in parliament today. And even a leader like Mrs. Gandhi, for that matter, or even Mr. Modi, who are so hugely popular with masses, are unable to even select 50 or 100 good parliamentarians to come into parliament, representing different walks of life. This country has great people. This country has some of the, perhaps as a race, we are second to none in the world. Second to none in the world. But those good people are not able to come into public life because they know that it is impossible to go into public life. It's become so dirty. To go into politics, fight election is not easy. It has become extremely dirty, and there is so much of money, so much of wrongdoing that is expected out of you. So good people are not willing to do. Now if they are not willing to do, then a leader like Mr. Modi or Mrs. Gandhi should have ensured that 50, 100 good people are selected by their parties, they win the election and they come into parliament. Lok Sabha, not Rajya Sabha. Even nomination in Rajya Sabha, I mean, if you are going to nominate likes of Gogoi to Rajya Sabha, what you have choice of, Mr. Nariman, for example, was a nominated member of Rajya Sabha, Mr. Fali Nariman, one of our finest lawyers. And he was the only member who opposed when entire parliament stood and passed without much discussion a law giving themselves perks beyond imagination of any citizen. He voted against it. He said, how can you do this? We are passing law in our own favor and we are giving us the money as we like. Nobody has scrutinized it, nothing. So, but those are people who are rare today. They are a rare commodity. And therefore, nothing can be done. And any kind of supervision is not going to work. Any kind of. The same people will get elected. You all see with our eyes open who are the people getting elected today. And we elect them because we have no other option. We feel that we have a duty to vote, so we go and vote. So that's the problem. It's a conundrum which cannot be solved easily now.
Hello sir, my name is Paul Johnson. I'm a fourth year law student of Government Law College. So in today's day and time, many social issues have been being raised, like very recently in Ernakulam, the smoke issue. And the High Court has intervened in this matter. So in your opinion...
What issue?
The smoke issue.
Smoke, yeah.
So how can the judiciary bring itself to involve in the problems of the common man? And so far, is there any limit to such involvement?
See, environment is one issue where judiciary has tried to do remarkable work. And the forests of India are saved, were saved at least till the present government has come. The present government unfortunately wants to, allow all kinds of development into forest. We are seeing the now damaging effects, irreversible damaging effect in the Himalayas on account of the Char Dham Yatra project, which is a pet project of Prime Minister Mr. Modi. Now, these are, judiciary has tried to stop so I think judicial intervention because of the failure of the municipal authorities here in Ernakulam, which led to this serious issue of garbage burning and resultant smog, I think is nothing but an attempt to correct the failures of the executive. And judiciary is the ultimate custodian of fundamental rights of the citizens. Right to life is an important, constitutional right. So judiciary has to protect that right. So judiciary feels that if environment is going to hurt the citizens, we must intervene and try and stop them. So, but judiciary can also act up to a limited point. It's for the executive to comply with their directions. So you know how the various ways they try and defeat the judicial dictates. So, but it's a constant battle. It will go on endlessly. Let's see what is in store. I don't know what is in store for future, but we have to hope for the best. What else one can do? We can only sit here and salute the judiciary. So that's it. Thank you very, very much.
So this will be the last question in the session.
Good afternoon, sir. My name is Abhi Roop. I am from Government Law College, Ernakulam. So my question is very simple, rather. I would like to ask you, what would be one thing that we should exclude from the basic structure of Indian Constitution? Something like the supremacy of the Parliament or something like that?
I think it's very difficult to say, because to me, every part of the Constitution is interlinked. And every part of the Constitution has a very important role to play. Some in our lives, some in governance, some in center-state relations. So in every which way, this is very important. But yes, it's not that in every case the Supreme Court has gone ahead and said that these are the basic features. There are many cases where Supreme Court has also said that these are not the basic features and therefore we should not treat them as such. But it depends on the facts. The test which I spoke about, that test really is determinative how Supreme Court would decide whether, as a provision, this particular provision is so important to the Constitution that without this provision, the Constitution will be redundant, or that it will be unworkable, or without this, citizens will find it difficult to survive. So, that's a test Supreme Court applies. And therefore, it's not that in every time Supreme Court will say it's an essential feature. Only about 10-20 features have so far been identified as basic features. Thank you. Thank you very much, everybody, for listening. Thanks a lot. Thanks for your patience, and thanks for coming on Saturday morning.
Thank you, sir, for answering the questions so patiently. I hereby invite Shri P. Shantalingam, Senior Advocate and President, Ernakulam Law College, Old Students and Teachers Association, to render the felicitation.
Mr. Dushyant Dave, former President of the Supreme Court Bar, and we hope that he will again become the President. And the dignitaries on the dais, my best friend Dr. Muhammad Uti Chinchi, after hearing the inspiring speech of Dave, I don't want to add anything at this hour. I only want to mention one fact, that in my college days, my professor Dr. A.T. Marcos made us to read one article which appeared as a leading article in the Law Institute Journal, Indian Law Institute Journal, which says which organ of the Indian Constitution is supreme, whether the legislature is supreme, whether the judiciary is supreme, whether executive is the supreme. And after analyzing all the articles in the Constitution, Professor Tripathi concluded that the will of the people is supreme. And after hearing Mr. Dave's speech, if people of Israel can demonstrate their willpower, their strength, people of India also in the equal measure, we can demonstrate our strength by making the people aware of their rights, how we can protect the social democracy by adopting constitutional means. And apart from this being a concluding remark, I don't want to say anything. Thank you.
Thank you, sir. I hereby invite Dr. Bindu M. Nambiar, Principal, Government Law College, Ernakulam, to render the felicitations.
Good afternoon, everyone. Distinguished Sri Senior Advocate Dushyant Dave, distinguished dignitaries on and off the dais, friends, and my dear students. Alumni Association, the Old Students Association, provides a forum, a platform for the alumni of the institution to keep a link with the college. It encourages the present students and the past students to be part of our college. I am proud to say that I am an alumni of His Highness Maharaja's Government Law College. Every institution should have a strong alumni association. It provides for the development and welfare of the institution to bring forth the best which has to be incorporated into the institution. I take this opportunity to congratulate the Old Students Association for organizing this lecture series, thereby making our students and for all of us to hear the eminent speaker, Sri Dushyant Dave. We all know that our country is a democratic country. To be a good democratic country, the people should be well educated. The Constitution is our supreme law. How many of the people in India know the provisions of the Constitution? If they are not aware about the provisions, then how can we say that this is a well-developed democratic society? As legal fraternity, it is our duty to educate our fellow citizens. So we should take this as a challenge. And as legal students, law students, you can teach your neighbors, others about these legal provisions and the rights of every person. We all know about our rights. How many of us do know about our duties? If only we do our duties, others will get the rights done. So, all of us should do our duty and protect the rights of others. Thank you, Jai Hind.
Thank you, ma'am. Last but not the least, may I now invite Shri P. Sanjay, Secretary, Ernakulam Law College Old Students and Teachers Association, to render the vote of thanks.
Distinguished guest of the day, and dear friends, we are coming to the close. We don't have enough time because Mr. Dave has to catch a flight. And I am really, really happy being the organizer of this event. When you see that the auditorium is almost full to the brim, that's what brings joy to us. I'm really, really happy. I'm sure each one of you will carry away with you whatever inspiring words that Mr. Dave has said. I thank you, sir. Thank you very, very much on behalf of the alumni, on behalf of the college, and on behalf of each one of you. I thank you, sir, for having joined us today. And of course, my thanks also goes to the other dignitaries in absentia, that is Justice Nambiar, the Law Minister, and Mr. Kurup, the Advocate General, who also had to catch a flight because most of them are now rushing to Chennai for the wedding that's happening. So I'm sure each one of you knows that. So thank you for all the college participants and my young friend here, the MC, and also the others who've helped us. Thank you so much.